Securities and Exchange Board of Act 1992, SEBI LODR Rules 2015, SEBI ICDR Regulation 2018, SEBI SEAT Regulation 2011, SEBI PIT Regulation 2015 describe the role, powers, and functions of the Security Exchange Board of India. Determine the severe regulatory and capital measures of India under the resolution of Government of India, specifically the prohibition of manipulative and deceptive devices, and including insider trading and substantial acquisition of securities and control, lay down penalties and adjudicating, identifying, establishment, jurisdiction authorities, and procedures of appeal tribunal. Allocate the significant regulation government by the SEBI and setting obligation disclosure requirement regulation 2015, SEBI issue and capital disclosure requirement regulation 2015, SEBI substantial acquisition of shares and takeover regulation 2011, and SEBI prohibition of insider trading 2015. Introduction. The Securities and Exchange Board of India was established in 1988. And it is not a legal character of 1992. The SEBI was primarily set up for regulate activities of merchant banks to control the operations of mutual funds, to work on the regulator to stock exchange activities, and act as a regulator authority new issue activities in company. The reason of SEBI is constituted was because before the SEBI was a law relating to securities market in India was contained a different establishment in Companies Act 1956, Securities Contract Act 1915, Security Contract Regulation Act 1956, Capital Issue Control Act 1947. Then all the time of capital market witnessed tremendous growth. Was found that registration was scattered in different laws and different administration agency and did not have a proper manpower to expertise the deeds of the investigations. Even there are no monitors or prosecuting machinery to check the malpractice, inside trading, etc. The government of India decided to set up an agency and regulatory body known as the Security Exchange Board of India. SEBI was established in 1998 as a statutory body for regulating security market. It became an autonomous body in 30th January 1992. Was acquired statutory power with the passing of SEBI Act 1992 by the Indian Parliament. In the year 1995, SEBI was given additional statutory power by the Government of India with an amendment of Security and Exchange Board of India Act 1992. Main primary objective of SEBI Act 1992 was protecting the investor interest on the investors and security, promoting the development of and regulating securities market for a matter connected therein with or incidental therefore. SEBI is a watchdog of security market, has an important and crucial role in regulating the market participants and perform then affirmation three duties in accordance with the regulatory norms. The preamble of SEBI describes the basic function of SEBI as to protect the interest of investor in securities and to promote the development of and regulate the market securities and the matter connected therein. The SEBI Act deemed to come with the force of 13th day of January 1992 extend to the whole of India in section 1 of SEBI Act 1991. 92. The important definition according to the two SEBI Act 1992 it follows some of the important definition of the terms board means Security Exchange Board of India established in section 3 and collective investment schemes. The schemes are arrangement which satisfy the condition specified under section 11 of section 2(1)(a). Judicial member, it means members of the Security Appeal Tribunal appointed under subsection of 15(a), including a presidential office. Member means a member of the board and including chairman. Regulation means regulatory of the board into the act. Reserve Bank means Reserve Bank of India Constitution section 3 of Reserve Bank. Securities means the assignment section 2 of the Securities Contract Act 2056. Technical member means technical members appointed under section 15(m) and 2. The words expression is not defined into the act but defined in the Securities Contracts Act 1956 and Depository Act 1996 and have been meant respectively assigned to them in the act. Establishment of Securities and Exchange Board of India. The establishment and incorporation of the board section 3, the SEBI therefore called as board was established under the as body corporate having a perpetual succession on a common scene with the power to acquire, hold and dispose of property, both movable and immovable property, to contract as also sue and sued by the name of SEBI. The head office of the board shall be Mumbai. Further, the board can establish office at the other place of India. Management of the board. SEBI as a management of the members appointed by the central government and the power the board constitute the following members. Members of the board is two chairmen, that is from central government, two members, officer of a ministry of central government, one member from RBI, five other members nominated by the central government. Out of the three, at least three should be whole-time members. The member, so எல்லாமே central government தான். So the chairman that all the members are referred to the section shall be a person of a person of ability, integrity, and standing that shall show capacity in dealing with a problem relating to the security market or having a special knowledge or a special experience of law, special experience in finance, special experience in economics, special experience in accountancy, special experience in administration, or any other discipline which is option of the central government shall be useful for the board, such as general superintendent, super direction, general direction, general management of the affairs of the board shall vest in the members of the board of the members, which may be exercise all the power and do all the act of things and which may be exercised or done by the board. The term of the office conditioned by the service of chairmen and members of the board, section 5. The term of office and other conditions by service of the chairman and members appointed by the section 4(1)(d). The five members of the appointment of central government shall be such of the prescribed rules that may be at right of termination. The central government has a right to terminate the service of the chairman, such as right to terminate service of the member appointed under section 4(1)(a), and that is five members appointed by central government at any time before the expiry of the tenure they can appoint, they can remove by giving not less than 3 months notice or 3 months salary allowance in lieu therefore. The chairperson, chairman, all the other members, not just the five members appointed by central government, shall have a right to relinquish office to any time before the expiry of the tenure by giving a notice 3 months in writing by central government. Term of office as per the frame of the regarding chairman, a whole-time member shall be hold the office of such person not exceeding 5 years, every director 5 years, as may be specified as the order of the appointment, but he shall be eligible for reappointment. For the provided that no person shall hold the office of chairman or member after attaining the age of 65. Okay. Removal of the member of the board, the chair board, central government, in 65 years, CAG, come control order generally 65 years. Removal of the member of the board. Central government shall remove the member of the office if he any time has been adjudicated as insolvent director, independent director has been declared by the competent court to be unsound mind director. He has convicted of offences which is opinion of central government involves moral turpitude. Same thing, director, independent director has an opinion of central government so abuse his position has rendered his continuance in office detrimental to public interest. ஸோ மக்களுக்கு பப்ளிக் இன்ட்ரெஸ்ட் ஏதாவது தேவையில்லாத வேலை பார்த்தா தூக்கிடுவாங்க. அப்படி இல்லை, அவரோட பதவியை தேவையில்லாமல் யூஸ் பண்ணால் தூக்கிடுவாங்க. Meeting of the board, section 7. The board shall meet with all the times, place and observe such rules of procedures regarding to the transaction of business in the meeting, including quorum of the meeting may be provided by the regulations. In absence of chairman, if any of the region chairman is unable to attend the meeting or attend any member after chosen by the member present from among themselves shall present to preside over the meeting. Decisions of majority vote. All the questions which comes up from before any meeting shall be decided by majority vote of the members present, and chairman or the presiding member will have a second vote, casting vote in the event of equality of votes. Majority vote 75% சொல்லல 51%. The majority vote 51% is the member not to participate in meetings or things. Any member who is a director of a company and who such a director has any indirect pecuniary interest of the matters coming up with the consideration at the meeting of the board. Related party transactionக்கு எப்படி அவர் வரலாம், ஆனால் வந்து மீட்டிங் அட்டன் பண்ணக்கூடாது, அந்த கோரம் இன்க்ளூடட் shall disclose as soon as possible relevant circumstances have come to the knowledge. தெரிஞ்சோன்னு சொல்லிடணும். The nature of the interest as such meeting and such disclosure shall be recorded in the preceding board, and a member shall take any part of the deliberate or decisions in the board with respect of the matter. Vacancy that etc. not to be invalidated proceeding on the board. Any vacancy in the board shall be invalidated at the act of proceeding of the board. Similar, the following event shall not be invalid, shall not invalidate the act of proceeding of the board. Any defect in the constitution of the board or any defect in the appointment or a member or person or member of the board or any irregularities in a procedure of the board not affecting the merits of it. So even though the member is vacant, so the act which is done by the member is valid. That is, and any vacancy in the board shall not invalidate any of the acts or any of the proceeding of the board. Similar, the following event shall not invalidate any of the proceeding of the board. The power of function of the subsidiary of power and function section 11. Subject to the provision of the Act, it shall be duty of the board to protect the interest of the investment securities. Investor securities and promote the development of and to regulate the securities market and the measure to think fits. The measure may provide for the regulation of the board business in stock exchange. Regulates the regulation of business and stock exchange and any other security markets. Registering and regulating the work of stockbrokers, that is stockbrokers, sub-brokers, share transfer agent, bankers to issue, bankers to trustees of trust deeds, registered to issue, merchant bankers, underwriters, portfolio manager, investment advisors, any other intermediates who may be associated with the securities market in any manner. Registration and regulating the work of the depositories, participants, but custodian of securities, foreign institutional investors, credit agency, and such other intermediaries of the board must may be notified of specify in the behalf. Registering the regulating or working of venture capital fund and collective investment schemes, including mutual funds. Promoting and regulating self-regulatory organization. Promoting fraudulent unfair trade practices regarding security market, promoting investor education training, intermediate security market, promoting prohibiting insider trading in securities, regulating substantial acquisition of shares and takeover of companies, calling of information from undertaking inspection, calling for information for undertaking inspection, and conducting inquiries and audit of stock exchange, mutual funds, and other posts associated with the security market, intermediate self-regulatory organization, security market, and calling of information record for other person, including a bank, any other authority, or a board or corporate establishment or are constituted by any of the state and state or state act which is opinion of the board shall be relevant to any investigation or inquiry by the board in respect of the transaction security. Calling of information from and furnishing information to authority, whether in India and outside India, having functions similar to those of board in the matter relating to the prevention or detection of violation respect of the securities law, subject to the provision of other law or time being enforced and record, providing the board purpose of furnishing information into any authority outside India may enter into arrangement or agreement or understanding with the authority with the prior approval of central government, performing its functions and exercising the power under the provision of the Indian Securities Act 1956 have been delegated to the central government, laying fees and other charges and carrying on the purpose of the section, conducting search on above process, calling for the furnishing any other agency as may be specified by the board, the information as may be considered necessary by it for deficient discharge of the functions. Performing such functions as may be prescribed in a power respect of inspection of books and documents. Further, the board may take measure to undertake the inspection of books, inspection of register, inspection of other documents or records are listed public company or public company which intend to get a security listed in a recognized stock exchange where the board has recognized ground to believe that such a company has been inducing insider trading and fraudulent unfair practices relating to securities market. Board are vesting same power as a civil court. The central board also have the same power as vested a civil court as per civil procedure 1909 by trying the suit the respect of the following matters, namely power of board will trying to suit discovery and production of books of accounts and other documents and the place and such time as may be specified by the board, summoning and enforcing attendance of a person, examination and oath, inspection of the board, register and other documents of person referred to section 12 and place inspection of the books and registered other documents and record a listed company, public company which intend to get security listed, issuing commission for the examination of witness documents. Passing an order of the board. A board may by an order by reason to record in the writing and interest of the investor security market take up the following measures. Either a pending investigation inquiry or complaints with the investigation inquiry, namely suspend the trading in any securities in recognized stock exchange, suspend restrain the person from accessing the security market, and prohibit any person associated with the security market to buy, sell, or deal in security. Suspend any office barrier of the stock exchange or a self-regulatory organization for holding such position. Suspend any office bearer stock exchange. Impound downs are retain the proceeding and security in relation to respect of the transactions which is under the investigation. Attach the attack attract attack. Okay. The period not exceeding 90 days, bank accounts and other properties, any of the attached entities, attached, K attack, attach. The period not exceeding 90 days, bank accounts or any other properties, any intermediate or any person associated with the security market in the manner involving in the violation of the provision of the Act or the rules and regulations made therein. Provide that board shall within 90 days of the said attachment provide the board shall within 90 days from the date of attachment obtain confirmation of the said attachment from the court attachment of the special court established in 26E having a judicial over the confirmation, and the attachment shall continue under the pendency of the aforesaid proceeding or conclusion of the said proceeding, and the provision of the transaction 28 shall apply. Provided further, only the property, bank accounts, or any other transaction entered herein shall be directed to the proceeding actually involved in the violation of any of the provision act, as the rules or regulation may therefore shall be allowed for attachment direct to any intermediate or any person certain. For the securities market in any manner not be disposed or alienated or the assets form of transaction which is under the investigation. Amount disgorged or pursuant to the direction issued by the SEBI Act, Security Contract Act 1956 or Depository Act 1996, as the case may be, shall be credited to the Investor Protection Fund established by the board, shall be credited, and the amount shall be utilized by the board in accordance with the regulations under the Act, providing the board may take any of the measures specified under the Clause D and Clause E and Clause F respect to the listing listed public company and public companies not being intermediate referred to the Clause 12 is intended to get the security listed in any of the stock exchanges when the board has reasonable ground to believe that such company have been indulging indulging insider trading of fraudulent unfair practices relating to security market. Provided further, the board shall either before or after passing an order give an opportunity to be hearing the intermediate person concerned. Penalty: the board may, by the order of reason of the recorded in the writing, or levy order under section 15A, 15B, 15C, 15D, 15E, 15EA, 15EB, 15E, 15G, 15H, 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 A, 15H, B, holding on the inquiries of procedural manner. Consequences: amount disgorged are pursuant to the direction issued any of the Act, that is section 11B of the Act and section 12A of the Security Contract Act 1956, section 19 of the Depository Act, section 1996 under the Settlement Act under the 915 JB, and section 23 JA of Security Contracts Regulation Act 1956 and section 19 1A of Depository Act 1996, as the case may be, shall credit to Investor Protection and Education Fund established by the board, and such amount shall be utilized for the board in accordance with the regulations made under the Act. Explain one example. The Security Exchange Board of India received certain information and complaint which have led to believe that a DA broker limited the registered mark and intermediate has violated multiple provisions of SEBI regulations. In the case, SEBI may at a time by writing an order direct any person hereafter in section refer to the investigation authority specified to order to investigate the affairs of the intermediate or a person associated with the security market and a report therein to the board. Therefore, the order of investigation into the affairs of the broker may be initiated.